I have to look at the community and protecting the community. And Mr. Schmidt was dead on the money when he said, 3 days. I sentenced you to probation in 3 days. Within 3 days, you committed these crimes. I'm only calling the misdemeanor case at this time. We will go on the record in the matter 23 CF 214, State of Wisconsin versus Bradley Scheuer. Oh, sorry, that's the 20. I'm not calling the new case.
Oh, you're not calling.
No, I'm only calling the, wait, you're right, the new case.
Do you want me to sit back in the,
Actually, no, you're right. I am only going to call the new case. And then I will call the old case after Mr. Davis excuses himself. So start anew. We will start afresh. We will go on the record in the matter 24 CF 202, State of Wisconsin versus Bradley Scheuer. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Scheuer in person in custody with counsel Nicholas Davis. We're set here today in this matter for a plea and sentencing. The parties have reached an agreement. Mr. Scheuer is currently in custody facing revocation on another matter. Mr. Davis, what is the agreement that's been reached?
Your Honor, the agreement initially was reached with Attorney Renicky, and I believe that District Attorney Schmidt is going to go along with that same agreement. My client was going to plead to count 3, Your Honor, which is misdemeanor battery. And it was just for both sides free to argue on this case.
All righty. So both sides free to argue in 24 CF 202.
And I should say at that time, District Attorney Renicky, I know that he always would include dismiss and read in. So those other 2 are not dismissed outright. They're dismissed and read in.
That is correct. All right. So Mr. Schmidt, what is the basis for the public interest in reaching this agreement?
I think being free to argue on that misdemeanor is fair. I think the way the false imprisonment was described by the victim, it's a little iffy. The strangulations are always about the effect on the victim, so there's always come down to testimony. The battery is the thing that we can certainly do. So I think that doing that and arguing with the read-ins is appropriate. Thank you.
Victim's rights compliance. Victim wish to make a statement? No statements made. All right. So, Mr. Scheuer, I have in front of me a plea questionnaire waiver of rights form. Do you recognize this document?
Yes.
And that's the document that your attorney went over with you? Did your attorney go over it with you?
Yes.
Did he go over it thoroughly with you?
Yes.
Did he essentially go over it word for word?
Yes.
And do you understand everything on this document?
Yes.
And if you didn't understand something, did you have him explain it to you?
Yes.
And he did so. Is that your signature on the second page?
Yes.
So you are pleading guilty to 1 count of misdemeanor battery. Is that correct?
Correct.
You are 66 years old. You have 12 years of schooling. You can read, write, and you understand the English language. Is that all correct?
Correct.
Did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did your attorney go over with you the maximum possible penalties you face?
Yes.
You are not receiving treatment for a mental illness or disorder, and you've not had any drugs, alcohol, or other medications in the last 24 hours. Is that correct?
Well, I'm on heart meds, but
That's
no.
all.
Yes.
No medications that interfere with your ability to comprehend or understand?
No, I've been incarcerated for 6 months.
All right. And so, did your attorney go over with you your constitutional rights?
Yes.
And did he go over them thoroughly with you?
Yes.
Do you understand them completely?
Yes.
You understand that you'll no longer have a trial. You'll no longer have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You will no longer have the right to testify on your own behalf or remain silent and not have your silence used against you. You will also no longer have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you will no longer have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand the rights that you're giving up here today.
Yes,
Now, do you also understand that if you're not a citizen of the United States, your plea could result in your deportation? If you're not,
yeah, I'm a citizen.
I know, I have to ask that to everybody. Do you understand that the state would have to prove on or around September 6th, 2024 in Burnett County, Wisconsin, you caused bodily harm to JEC by an act done with intent to cause bodily harm to that person without that person's consent, a Class A misdemeanor? Do you understand what the state would have to prove?
Yes,
Do you understand that upon conviction, you face a fine of up to $10,000 or imprisonment of up to 9 months or both?
yes,
Do you understand that there is what's called a free to argue here? And that means that the state is free to argue for any sentence it feels is appropriate based upon the facts. Your attorney is free to argue any sentence that he and you feel is appropriate based upon the facts. But I'm not bound to follow either of those arguments or recommendations. Do you understand that?
yes,
That I am free in my own discretion based upon the facts of the case, as well as the totality of the circumstances, your history, rehabilitative needs, etc., the community, to sentence you to what I believe would be an appropriate sentence. Do you understand that?
yes,
Do you still wish to proceed and enter a guilty plea?
yes,
Now, did you go over the criminal complaint with your attorney?
yes,
In particular, did you go over that probable cause section that basically says what happened and why you were charged with the crimes?
yes, I read it, but I don't agree with it.
Well, and that's what I'm going to say. You may not agree with all of the facts 100%, but as it relates to this battery charge and the battery charge only, for those facts, are they essentially accurate?
No,
Well, I'm not taking his plea. We're going to go to trial because he's contesting it. He doesn't believe he did anything. We're going to trial. Okay, Mr. Davis, let's set the matter for trial. Then I'll move ahead and I'll sentence
I
him on
agree,
the other
I
matter.
understand what you're
No,
saying, but I do.
Nope, because you're not admitting to what you did.
Fine, I admit to it then.
Mr. Scheuer, I am not accepting a plea of an individual who is not going to be accountable and responsible for their actions, especially when it involves a battery to a person, a battery to a victim who did not deserve to have you put your hands upon them. Do you understand that? Now,
Yes.
if you're willing to accept that responsibility and admit to what you did, I will proceed and accept a plea. But if you are not, then we will go to trial. And I want you to tell the truth and be honest with what you did and your actions that day, or we will go to trial. I do not have any preference one way or another. I will not accept a plea if you are not guilty. I will allow you to attempt to prove your innocence or have the state prove your guilt beyond a reasonable doubt as to all of these charges to a jury. That is the justice system. So, Mr. Scheuer, I will again ask you, what did you do that day?
I put my hands on her.
You did. Did you? You put your hands on her.
That's what I'm charged with.
Yes.
Yes,
Did you put your hands
Yes.
on her? Did you have a right to put your hands on her?
yes,
You had a right to? The law says you can put your rights upon a person?
no,
Did you have a right to put
No.
your hands on her? Now, Mr. Scheuer, so you put your hands upon JEC, is that correct?
yes,
Did she give you consent to do so?
no,
Did you have a right to do so?
no,
Did you cause her harm?
yeah,
What?
yes, I said.
Yes, you caused her harm. Therefore, Mr. Scheuer, are you guilty of battery?
Yes,
Now, with regards to the facts of the case as it relates to battery, did you review that with your attorney?
yes,
Now, Mr. Scheuer, tell me right now, those facts as it relates to a misdemeanor battery, are they not 100% accurate, but are they for the most part as it relates to battery accurate?
yes,
Are you telling the truth?
yes,
Raise your hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Mr. Scheuer, are you telling the truth here today that the facts alleged in the criminal complaint as it relates to the misdemeanor battery are for the most part accurate?
Yes.
Are you stating here today that you in fact did lay your hands upon JEC?
Yes.
Are you stating here today that you in fact did not have consent to do so?
Yes.
Are you stating here today that you did in fact cause bodily harm?
Yes.
So, Mr. Scheuer, one last time, as it relates to the facts alleged in that criminal complaint, as it relates to battery, are they for the most part accurate?
Yes.
Mr. Davis, may the court use the probable cause section as well as the statements made under oath by your client to find a factual basis?
I think the court has made a solid record, so I would agree with the recitation the court had with the defendant. Thank you.
Thank you. Now, Mr. Scheuer, has anyone made any threats or any promises to you for you to plead guilty to this charge?
No.
You're doing so freely and intelligently. That means you, yourself, you're telling me that you fully understand what you're doing here today,
Yes.
and you're doing so voluntarily.
Yes.
Now, when I walked into court here today, you were making jokes, you were talking to your attorney, you were having a good time. So that's telling me that you like Mr. Davis.
Yeah.
He's a good attorney.
Yeah.
He's a great attorney, actually.
Yeah.
He's a good guy, right?
Yeah.
You get along with him.
For the most part, yes.
Yes. Now, Mr. Davis, did he provide you at least competent representation?
I believe I provided him competent representation whenever he needed a question or a meeting or some kind of phone conference that was provided to Bradley.
So, Mr. Scheuer, did your attorney provide you competent representation?
Yes.
Did he go over the facts of the case with you?
Yes.
Did he go over the facts of the case with you as it relates to the elements the state would have to prove?
Yes.
Did he go over with you the evidence and the discovery in this case?
Yes.
Did he go over whether or not you have any defenses or a lack of defenses in this case?
Yes.
Are you satisfied with his services?
Yes.
Now, Mr. Scheuer, do you have any questions for the court?
No.
Your Honor, may I say, I just have one sidebar with my client?
You may.
Remember, you wanted this done.
Mhm. Mhm.
Your Honor, I just want to make a record. My client, again, he's ready to proceed, and everything that he's put on the record is honest.
And for the record, I know you were talking to your client, but quite honestly, this is a courtroom. I have ears. I can hear very well. You were talking to him about his right to go to trial. He has the right to go to trial if he wishes to do so. That is his constitutional right, and he wishes to waive that right, and he wishes to enter this plea here today. Is that accurate and true, Mr. Davis?
It is. I just wanted to make sure one last time that if he wants to have a trial, I will make sure that I will represent him in that trial. And I said, well, and you will give him that access to that trial. And he said that he wants to go forward with this plea. I just wanted to double, triple, quadruple check on this.
And Mr. Davis, that's because you are a really good attorney, great attorney. He does his job very well and he's very thorough. So thank you, Mr. Davis, for doing that. So is that all accurate and true, Mr. Scheuer?
Yes.
All right. So you wish to waive your right to a jury trial here today and you wish to enter a plea. Is that correct?
Yes.
And Mr. Davis, based upon your conversations with Mr. Scheuer, do you believe he is freely, voluntarily, and intelligently entering a plea here today?
I know he is, Your Honor. Yes.
And he understands what he is doing by waiving his constitutional rights?
Bradley is an intelligent man. He understands.
All right, then. Any questions before we proceed, Mr. Scheuer?
No.
As to count 3, battery, and a misdemeanor, how do you wish to plead? How do you wish to
Guilty.
plead?
Huh?
How do you wish to plead?
I said guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis based upon your statements under oath to find a factual basis in this case to accept your plea. Therefore, I will enter judgment as it relates to the battery. I will dismiss and read in counts 1 and count 2. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
Thank you, Judge. I would ask the court to consider doing a jail sentence of 6 to 9 months. The court's first supposed to look at probation. I think probation is clearly inappropriate here because this offense happened 3 days after Mr. Scheuer was placed on probation on a different offense, a felony offense. So it'd be pretty wild under the McCleary-Gallion factors if the court did probation on this case. So for determining what would be appropriate for a jail sentence, I think that when we look at Mr. Scheuer's history, it goes back 20 years and it's pretty consistent. There's lots of alcohol-related offenses, OWIs of different levels. He has a lot of domestic and DC and battery type offenses. He's got a past pistol or assault weapon charge from McLeod County, Minnesota. So seeing that history and seeing those three things come together again, even though he has 20 years of history of it's kind of concerning. It's not kind of concerning, it's highly concerning. The conduct described here also involved weapons. The victim originally called about a machete and something else. Law enforcement saw him with a drone with a crossbow firing towards it. He didn't hit the drone. He hit the drone. That would have been just tens of thousands of dollars of restitution. So Mr. Scheuer's lucky he didn't shoot that drone out of the sky. This was an incident where, again, he hurt someone. He has past convictions for hurting people. He's been on probation numerous times. He's been to prison numerous times. With Mr. Scheuer, I think he's a person where we need to be thinking about punishment. We need to be thinking about specific deterrence. And we need to be thinking about general deterrence. The public needs to know, like, if someone, 3 days into probation commits the same-ish type of offense that they've always committed, that it's not just going to be, well, the answer to this is more probation. Because then people know that their conduct isn't punished, and that opens up people to behave like that. Scheuer in particular needs to be communicated to that this will be punished. There's a ratcheting punishment system. The McCleary-Gallion factors are such that as time goes by and you commit more offenses, the penalties graduate upwards until you stop doing those. That's what specific deterrence is. So we've also clearly established that he does have rehabilitative, needs. Alcohol has been a primary driver in his whole life, and no doubt in this offense. But it can't be in the community with probation. Again, this happened 3 days into probation. So for those reasons, I think the court should do a jail sentence. It should be in the longer range. It should be 6 to 9 months. Thank you.
All right, thank you. Mr. Davis, argument and sentencing recommendation, please.
Thank you, Your Honor. Well, Your Honor, this case was interesting in terms of if it had gone to trial. I think there were some good defenses in this case, especially with regard to the felony, the 2 felonies, and even the battery. I'm not quite certain that the victim was even looking for any kind of prosecution. And I was suspect that the victim was even going to show up if it had been set for trial. However, in preparing for these cases, I have to also listen to the advice of my clients as they should listen to mine. But again, I work for the client. And I explained to Bradley, if he wants a jury trial, we can most certainly have it. And he knows that. And you grilled him on that too. But at the end of the day, he did put his hands on her, grabbed her wrists, and she said it caused pain. And so he's admitting to that. Again, there are different levels of battery. He's a convicted on a misdemeanor battery. That's not a badge. And I know that he has a prior record. Now, I've seen much longer prior records. I've gone through it, and I've seen records that are not as long as his, but he does have a prior record with the OWIs, Your Honor. Those are certainly on there. I did see a felony bail jumping. I think I saw disorderly conduct too. I think that may have been St. Croix County. But in any event, he does have a record, but I wouldn't say it's where you go on the court access system and you're scrolling through 4 pages. Bradley's been sitting for a very long time. I know that he was, I don't have the exact number of days, but he's also been sitting on a hold though from the revocation. And so I don't have the exact number of days for this case. Sorry, he does, because he's been sitting in jail.
And it would depend upon whether or not the court would do it consecutive or concurrent to any other sentence regardless.
He has 164 days for this case. Not that's just with this, not with regard to the revocation. And so obviously you're going to be sentencing him here on a sentencing after revocation. And I don't know what's going to happen in that. But in this particular case, Your Honor, I don't see that there is any drugs or alcohol involved in this. And depending what's going to happen in the other case, I was going to ask the court to consider, I was going to ask for somewhere between 30 days and 3 months. And I believe that would be time served if he was given good time. And again, I would ask the court very respectfully and politely that if his whatever sentence he has, it can run concurrent to the case that you have next, Your Honor. You are aware of Bradley, you know Bradley. And when I was talking to Bradley, I get along with my client and we've gone butted heads before, but that's what usually I do with my clients. But I can tell you he's sincere. He's not a liar. And he admits to when he does wrong. And you asked him and he said that he did it. He was not allowed to touched her. And did it cause her pain? It sure did. And did he have the intent to touch her that caused pain? And it did. He did that. Now he's guilty of it. So I know that if he's not in jail, I know that he's able to work and be successful and take care of himself. He's not been a drain on society in terms of that. He's not a lazy man. He's not a stupid man. So I think when he's not in relationships that he should not be in, and this had nothing to do with drugs or alcohol, he's just a good person, and he means well and he does well. And this was not a relationship either. There was not a relationship between these two. That was more of a working thing.
That's what's weird is because in the criminal complaint, the probable cause, which comes from the police report, it identifies her as a girlfriend. It identifies her as something over a period of time, but this could have been something what could have occurred over multiple other incident dates.
And I suspect that I'm just suspecting when Attorney Renicky was going through this and charging this out or whatever, maybe he had contact with the victim in this case, and maybe she also said I was not in a relationship with him at this time period.
Well, and I will go over to the district attorney now to ask from their perspective, because I'm going to say quite clearly in the criminal complaint, which comes from the police reports, which comes from their investigation, which comes from the statements from the witnesses and the victims, it states she is the girlfriend. It states that on September 6, 2024, I, Deputy Henry, was requested by dispatch to respond to 26589 Old 35 in Menon Township. Dispatch advised that probation agent Lineweber was at the residence looking into allegations that Bradley Scheuer assaulted his girlfriend, JEC, last night. And if you go down, it says in the middle of the paragraph that she was worried about further retaliation from Bradley, as he told her numerous times that he knows people and he can hurt her even if he's in prison. And where else did it say? He threatened to burn her alive in the camper. Where else does it say other things like that? But
the defense agrees that that's in the complaint, but again, I don't think that she's saying that she was in a relationship with him. The only thing that I had read from it is they were investigating allegations that she was assaulted his girlfriend.
Schmidt?
I'm the one who charged it. The reason it doesn't have the domestic abuse surcharge is boyfriend, girlfriend is not something that creates the domestic abuse surcharge in Wisconsin. It's whether they're married or reside together or have children together. Being boyfriend and girlfriend does not make it a domestic abuse offense in Wisconsin. That is why I did not.
Well, and quite honestly, whether or not he's guilty of the charge and how it is charged doesn't really matter if it's boyfriend or girlfriend. Well, granted, if it is a girlfriend, you probably should care for that person and not want to harm them, but you shouldn't want to harm anyone. So, Mr. Davis, I don't know. I don't know if it's a girlfriend. I don't know if it's not a girlfriend. I don't have the victim here. I don't believe in court here today. I just know what was reported to law enforcement. And I don't believe that law enforcement would make something up and put that in a police report. And that's where we get the criminal complaints and the information from.
Well, just
law enforcement.
In my argument, Judge, my client was not in a relationship with her when this occurred. And it's my belief that I think that she did live in Minnesota too at the time. They were not residing together. At least